Excellent. Thank you all very much for being here, but particularly thank you to the organisers of this event, to Mia and to David, to the University of Johannesburg. It's a real honour to be here to talk about the ICTR and its legacies. And what I want to do in my presentation this morning is address this issue of the ICTR's legacies, particularly from the vantage point of the Gacaca courts in Rwanda, and particularly from Rwandan participants within those courts. And I'm going to be drawing a lot on the empirical work that I've done in Rwanda over the last 12 years. I've conducted about 700 interviews at all levels of the transitional justice scheme in the country. As Mia mentioned, I've written this book on Gacaca. This is a completely blatant plug, but I've also got a small version. This is the kind of 13-page version of the 400-page book, and there's a pile of them there. And can I please beg you, even if you're not at all interested in my work, please take this, because if you don't, I then have to carry about 25 kilos worth of books back to London, and I have a bad back at the best of times, so you'd be doing me an enormous favour if you took this little green book away. So I'm going to be drawing a lot on the content in that book, but as Mia also mentioned, I'm finishing a book at the moment looking at the ICC in Uganda and the Eastern Democratic Republic of Congo. So to a lesser extent, I'm also going to draw on some of the empirical work that I've done for that particular project. What I want to argue in a nutshell today is that while the ICTR has undoubtedly contributed a substantial jurisprudential legacy, I'm rather sceptical that the ICTR will in fact have a long-lasting and meaningful impact on the lives of everyday Rwandans. And I think therefore we should be very sober and very circumspect in our discussions about legacy over the next 2 days, particularly in terms of legacy for the Rwandan people themselves. And I want to build this argument by making two main points, or highlighting, I guess, two key problems that I see with the work of the ICTR over the last 17 or 18 years. And these two problems kind of centre on one word. They centre on a single theme, which is the theme of the ICTR's distance from the Rwandan people, from the country most affected, obviously, by the genocide. So I'm going to come back and say quite a bit about this word distance in just a moment. And in doing so, I want to suggest that there are some fundamental tensions at the core of what the ICTR has tried to do over that period. These are problems, I think, that also are having a key spillover effect in terms of the work of the ICC. And in many ways, I think the ICC at the moment is being hamstrung by some of the negative legacies of the work of the ICTR. So let me turn to the first problem that I see in the work of the ICTR, particularly connected to this idea of distance. And I think the ICTR in many ways from the outset struggled to fully understand the nature of the Rwandan conflict and how ideas of accountability should be interpreted on the basis of that understanding. This, I think, has been a structural problem for the ICTR right from the outset, that in many ways, especially in the early years of the tribunal, it didn't have a very deep knowledge of either Rwanda, and it didn't have a particularly deep knowledge of the causes of the genocide itself. And to a certain extent, this was very understandable. The tribunal was set up in the immediate aftermath of the genocide. This was an extraordinarily destabilised period. But I think one of the elements that we saw right from the start was the ICTR's heavy reliance on international personnel rather than Rwandan personnel at all levels of the institution. But perhaps most saliently, particularly at the investigative level, that so much of the early work of the tribunal on the ground in Rwanda was fundamentally done by people who didn't in fact know the context particularly well and had to spend an enormous amount of time getting up to speed even on just the fundamentals of the history, the society, the politics of this country. And it was only much later in the piece, in the tribunal's lifespan, that in fact Rwandan specialists were brought much more into the work of the tribunal. So there was this kind of heavy reliance on international and external expertise. And I think as a result of that, what we saw from the tribunal almost right from the outset was that it in essence applied the Nuremberg model of justice to an idea of a conflict like the Holocaust. That in fact Nuremberg and the Holocaust was very much the backdrop to the way that the ICTR went about its early work. And embedded in that idea was a particular conception of violence, a very particular conception of conflict. In that model, violence is seen as fundamentally elite-driven, it's seen as top-down, and it's seen as orchestrated from the centre, and then spreading to the periphery from there. And as a result of this conception, there was also this emphasis on the most responsible, who from the outset were interpreted as individuals in Kigali, particularly senior military and political personnel. And so the Holocaust, I think, loomed very large in the background of how the ICTR began its work. But of course, as we know all too well now, particularly as the literature on Rwanda has developed, the genocide was much more complex in Rwanda than simply this depiction of a top-down enterprise. That focusing simply on elites, in fact, doesn't explain why it is that hundreds of thousands of Rwandans decided to pick up machetes and kill people that they knew extraordinarily well. Yes, of course, there was a key element of elite orchestration, but that's not the full story. That might have been the beginning of the genocide, but it certainly doesn't explain all of the fundamental events over those 3 months of the conflict. And here I'm drawing particularly on the work of people like Scott Strauss, Leanne Fuji, Omar Makdoum, who've written rich ethnographic accounts, particularly based on interviews with genocide perpetrators in Rwanda, highlighting that elite orders and coercion, in fact, played a very minimal role in the lives of most everyday civilians who took part in the genocide. That in fact, elite coercion is a very tiny part of the picture, they would all argue. And much more localized motivations, often based on greed or fear, a desire for self-defense, settling scores from past disputes, in fact go much deeper in terms of explaining why this genocide happened in the scale and with the speed that it did. And what these authors also highlight in terms of the complexity of the Rwandan genocide is that, of course, this isn't a single monolithic conflict that we're talking about. We're actually talking about a very dynamic and diffuse event that looked very, very different in different parts of Rwanda, and it looked very, very different at different points of time in the conflict. So we might talk about the Rwandan genocide as though it is this single homogenous event, but in fact, it changed course rapidly over the space of those 3 months. And so there's a sense of the conflict being dynamic. It took on a life of its own. Yes, it might have started with elites, but once it got out into the countryside, it took on much more complex dimensions. And in many ways, I think the ICTR's model of conflict didn't capture this diversity and this complexity. More importantly, though, and I don't simply want to draw on the academic literature here, what I think is more important is that the ICTR's model of conflict, its idea of a Holocaust-style genocide that informed all of its work, in many ways doesn't resonate with the way that everyday Rwandans talk about the violence. Particularly the ICTR's emphasis on those who are considered most responsible. These elites in Kigali who are seen as vital in terms of orchestrating the conflict. Because what we see in Rwanda, and it resonates in places like northern Uganda and eastern DRC, where I do my research as well, is that in cases of intimate conflict, where hundreds of thousands of people have often been involved in the committing of violence, when you talk to individuals at the community level, whoever they might be, whatever background they come from, and you ask them, who do you consider most responsible for this conflict? It's very rare, in fact, that they will point to the senior leadership in a place like Kigali or Kinshasa or wherever it might be. In fact, because the violence was carried out, typically in a very intimate fashion, the most responsible perpetrator in the minds of most people is the neighbour or the friend or the family member who picked up a machete and killed someone that they knew extraordinarily well. So in my interviews in Rwanda over the last 12 years, this has been a salient feature of people's discussions about the past. People don't talk about the genocide in the countryside as, oh, that thing that Kambanda did, or that thing that Bagasora did, although they recognise that those individuals played a role. They talk about it in terms of the guy who lived next door, who we knew extraordinarily well, who we couldn't believe did these terrible things in 1994. So what all of this does, I think, is it messes with this division between high and low-level perpetrator and this conception of who we might think as most responsible. And this isn't just, kind of abstract academic findings. This matters if we think about legacy. Because if one of the audiences of legacy is the Rwandan people who lived through this conflict, having a tribunal that in many ways built upon a conception of conflict that doesn't resonate with the vast majority of everyday people means we've got a problem. That in actual fact, I think there was the importation of an old model of how violence took place, and in many ways it didn't capture the complexity and the decentralization of violence that we've seen in a place like Rwanda and not just Rwanda. 5 minutes. I have a tendency to do this, to kind of get carried away. let me say sort of two very quick things, and then I'm going to wrap up. The one is just ending this first problem, this issue of a sort of an imported idea of violence that doesn't resonate at the local level. I think one of the great contributions of the Gacaca process is that it has identified individualized suspects at the community level, and it has dealt with the conflict in a way that makes sense to people who live through the violence in the first place. In many ways, it reflects the subjective experiences of people who actually lived through the genocide. Now, Gacaca is a profoundly imperfect system, and this is something that I argue in my book, but it does have that immediate resonance because it seeks to address the conflict in terms that would make sense to the people who lived through it. So I think there's a kind of distanced conception of the genocide that the ICTR is built upon, and it has enormous ramifications in terms of legacy. Let me turn very briefly now to the second problem in terms of distance that the ICTR, I think, has experienced really from day one, and that is a confused understanding of its own institutional role. One of the challenges for the ICTR, and it's a challenge in many ways for all international criminal legal institutions, is how to deal with a core tension between wanting to deliver justice in a very distanced and detached way, i.e. to be neutral, to be impartial, to not be captured by domestic, social and political dynamics, to deliver this kind of impartial international justice, while also wanting to have quantifiable impact on the ground, wanting to have consequences, and as we're talking about today, to have legacy. And I think at the heart of the ICTR from day one, and at the heart of institutions like the ICC, is in many ways a confusion about what these institutions are all about. Is it about separation from the society in question in order to deliver neutral justice? Or in fact, is it to get on the ground, to have tangible consequences? Is it to remain distant, or is it to be embedded? And I think right from day one, the ICTR has struggled to come to terms with this particular issue. I think fundamentally, built within this notion, is in fact, at the international level, a profound suspicion of the domestic arena. I think if we look at the core of international justice, in fact what we see is a notion that the domestic arena is a dangerous place to a certain extent. It's a place that might co-opt us. It's a realm that might manipulate us. We as international actors might get infected by dynamics on the ground. So with that impulse, with that philosophy underpinning even the idea of international justice, what chance is there of tangible consequences for people who live within that particular society? Let me encapsulate this with an interview that I did with a senior ICTR judge in 2003. I was a very naive PhD student at Oxford. I'd never been to Rwanda before, and then I stumbled off to Arusha, and I interviewed this judge, and I said, look, I've been looking at your statute, and this might sound like a naive question, but apparently you're supposed to be contributing to national reconciliation in Rwanda. Now, what I'd like to know is, you've been at this tribunal now for 5 or 6 years. Have you been to Rwanda to see how much progress you're making in terms of national reconciliation? And this judge looked at me, perhaps quite rightly, as though I was a kind of space alien. And he said, look, go to Rwanda? Are you mad? He said, why would I want to go to Rwanda? In fact, I never want to go to Rwanda. Because if I go to Rwanda, I'm going to see things that will affect me emotionally. I will meet people. I might build relationships. All of that is going to make my job as an international judge much more difficult. And I thought, wow, this is really remarkable. I mean, from a PhD student's point of view back in those days, this was perfect. This was that kind of quote that you want, that kind of encapsulates an entire mentality. I mean, it was an expression of the virtues of distance, the virtues of separation. And it struck me that you wouldn't buy a used car on that basis. You know, the less we know about the context, the better. You know, the less we know about. And I was like, oh, this is very interesting. So I describe this in a jocular way, but there's a kind of serious point here, which is that I think this, in many ways, encapsulates a very important mentality, not just within the ICTR, but within ICL much more generally. This kind of suspicion of how attached should we get, how much interaction should we have in the local domain, and I think there's something very, very dangerous there. So let me absolutely wrap up. I had many more things to say, but it's always the case. I'm sure we can deal with this in the Q&A. I think the problem of these two sort of dynamics around distance is that it calls into question how serious the ICTR has been from day one in terms of In fact, having tangible legacy on the ground in Rwanda, what kind of effects it would have. Gacaca, for all of its imperfections, and it has many, many other challenges, hasn't had the same problems on these two levels. Because if nothing else, from day one with Gacaca, there was firstly a clarity of who the audience was. The audience was the local people. It wasn't abstractions in terms of international jurisprudence. It was always, we have to deliver something tangible for the people who lived through the genocide themselves. And all of its operations have been generated around that core idea. These issues of distance and disengagement never really came into it because the trials were being held in communities involving everyday people. And so at least on this point, Gacaca, I think, had a much greater intellectual and practical coherence, and it wasn't bedeviled by many of the problems that we're seeing in terms of the ICTR. What's interesting, I think, at the moment is, I would argue, the ICC is picking up on many of these same tensions and confusions as the ICTR. You only have to listen to the prosecutor, whether it was Ocampo or whether it's Bensouda, talk about what this court is supposed to do, and you hear this confusion. Ocampo, when he turned up in northern Uganda for the first time, I was there at his press conference in Lulu, Ocampo said, we can end this conflict in 6 months. I mean, this was remarkable. To people who had lived through a kind of 15, nearly 20-year civil war, you're coming in with international justice, you're going to fix it. And you've got a time frame. I mean, that's really remarkable. 6 months, not just somewhere in the future. 6 months. By next March, it'll be done and dusted. We'll be dancing in the streets. Remarkable, right? By the time he got to Congo, having been burnt by the LRA situation in northern Uganda, the message was completely different. Oh no, it's not about consequences on the ground. It's not about tangible impact. It's not our role as international justice practitioners to have an impact there, to change the situation in the country. This was Ocampo's kind of famous phrase. So you see that tension, you see that confusion. And what I think ultimately, when it comes to issues of legacy, is we have to ask ourselves, how is it with these problems around the idea of distance that in fact international law can have tangible positive benefits on the ground in the countries that we're talking about? Thanks very much.